Yes.
May I praise Lord? My Lord, this is an appeal under section.
What is wrong in the order?
Wrong is, Lordship, the court does not, commercial court does not have any power to extend the time for filing
So
of the.
what you are proposing is that if plaint is not submitted to the defendant, yet the defendant must file the written statement without
No,
without the
it was-
plaint.
It was supplied to the
Even the order says 11/4. There was an order to give him document number 31. That
Lordship,
document you gave on a particular date.
Summons were sent by registered with AD in 2 envelopes containing the weight of that envelope was 1 kg
59 grams.
59 grams, Lordship. And nowhere the defendants pleaded
No,
that.
you see, though that is, Mr. Roy, that has gone by. You send a summons on the day when he appeared. You gave another copy of the plaint. So
Huh.
that matter ends whether you serve.
No, Lordship. There is Apex Court decision, Lordship, 2009.
Look at the order of 11/4. Read that order. First line is that you supplied copies.
Or Lordship, what happened when I sent the summons documents along with the injunction application to the defendants, Your Honor, under registered covered with AD. They received it on 10th of March, 23.
No, it's over. That we have understood. But look at the order dated 11/4.
Yes, 11/4, Lordship, court directed me to supply the extra copies, Lordship.
And you
documents
supplied.
and the plaint, which
So
I supplied.
we'll have
From
to.
that date also, the defendant did not file the WS within 120 days.
No. The document number 31 was not there.
Document number 30 was in nothing, Lordship. This is printout was given in the Commercial Act, Lordship. If there is an electronic device, if the printouts have been given.
Correct.
there is-
So
there is-
therefore, on the date of service report, you are proposing that the court should look at the plaint, what are the documents, whether one of the document is a printout of the CD, and then take a cognizable, well-researched decision that the copy was served. Then why you have annexed a CD if you don't want to supply a copy?
No.
If you have supplied-
I had given the printout, Lordship.
No.
On
You
that
see,
day, Lordship.
once a document is there, whether it is a printout or not, how should I know?
No, Lordship, as per the Commercial Act, Lordship, if the photo print of the CD is given, that is sufficient. Lordship, may please to peruse the provisions of
why
the
is that-
Commercial Act.
Why is the document 31 annexed? You should not have annexed it. If you have
Next,
annexed,
Lordship, as per the amended provisions of the Evidence Act regarding
That is
electronic
why-
devices.
when somebody is giving a written statement, he will definitely go to the CD and see
Lordship,
if it is right or wrong.
may be pleased to peruse the impugned judgment, where the learned trial court has given the finding that even if the documents were given, then I am exercising the power under section 151, inherent power, and allow the defendant to
You
file
see, that may be wrong in view of SBT.
Lordship,
But
when this law has been settled by the Apex Court in 2019 SCC, that judgment is that 151 will not apply, and inherent power
that is okay.
cannot be.
But then you come to the merit.
And that
how-
judgment was cited before the learned judge. The learned judge had discussed that judgment, but regarding 151, where the finding of the Supreme Court ratio is this, Lordship, that the commercial
Mr.
court
Roy-
cannot exercise the power under
Mr.
section
Roy-
151.
Written statement, allowing of filing of the written statement is not an appealable order under section 13.
Yes, appellable order. Yes,
Show that.
very much appellable. Commercial. See section 13, decree or order.
Read that. Read that there is 1A.
Yes.
There is 1A.
Lordship, first of all, section 30, any person aggrieved by the judgment or order of a commercial court below the level of the district judge may appeal to the commercial appellate court within a period of 60 days from the date of the judgment or the order. A is any person aggrieved by the judgment or order of a commercial court at the level of district judge, commercial exercising original civil jurisdiction, or as the case may be, commercial division of a high court may appeal to the commercial appellate division of that high court within a period of 60 days from the date of the judgment or order. So if an
Next.
provided that an appeal shall lie from such order passed by the commercial division or a commercial court. Here, order has been passed by the commercial court that are specifically enumerated under Order 43 of the CPC as amended by this Act and
This is the
Section
limiting provision.
37 of the
This is the limiting
Arbitration and
provision.
Conciliation Act.
This is the limiting provision. It will lie only against other orders which are otherwise applicable under Order 43.
My humble submission is this, Lordship, if an order is passed which seriously affects the party lordship, in the present appellant, that as per the order section 13 of the Commercial Courts Act 2015, an appeal will lie to this honorable court.
Okay, we'll deliberate and pass orders in the chambers.
Lordship, I would like to place the only Supreme Court decision, Lordship, only few. Lordship, supply. Just. Thank you. दोनों दिया है।
Which are the paragraphs?
Paragraphs are Lordship. Lordship, may come to page Supreme Court Judgment 2019, Lordship. 2019, 12 SCC, page 120.
This is 151 does not apply.
Yes.
115 does not apply.
The improved order, Lordship, the learned trial court come to the finding that I am exercising the inherent power under section 151. The defendants are allowed to file the WS.
Correct.
So, and this judgment was surprising enough. This judgment was cited before the learned trial court, and that judgment had been discussed. But regarding the power under section 151 cannot be exercised, there is nothing, Lordship.
Okay.
And
This-
other judgment, Lordship,
Axis Bank, what is the
other judgment of the Bombay High Court, Lordship, para Lordship 99 and 100, page 70. This is one of the leading judgment of the
70.
Bombay High Court.
is 70?
Yes, at the bottom page number is given, Lordship.
Huh.
Lordship, may I please to come to page Lordship 69 first, conclusion. Page 69, page number is given at the bottom right side, Lordship. Conclusion. In view of findings as above, I decide the question of the framed by this court as under. In commercial suit, a written statement by the defendant cannot be taken on record after the expiry of 120 days from the date of service of the writ of summons. Then Lordship, para 99, same page, bottom. I find that ever since its introduction, the Commercial Court Act has already instituted a sense of urgency amongst the legal fraternity. Litigants alike are now conscious that they are required to move in expeditious and vigilant manner as their earlier available remedy of filing application for condonation of delay has now been taken away. In the light of the aforesaid and in view of the stand correctly being taken by the Apex Court and Delhi High Court, I see no reason as to why our court should not should fall behind merely because it is a charter high court. Our court must commence all necessary steps to ensure the commercial.
Mr. Roy, there is some urgency. That is why we are not reading it, because Mr. Dilip Hazarika, senior advocate, has expired. His dead body will come at 10:30. So therefore, we intend to break and then the next TV will sit. So they will take,
Lordship,
we'll take into
meantime,
consideration.
because the date is fixed tomorrow, Lordship.
I understand.
For filing
69.
and Lordship, till then,
we'll consider.
further proceeding of the suit may be a state
We'll
law.
consider. We'll
And
consider
notice
and
may be
take
issued to
decision.
the respondent.
We'll consider. Para 96 onwards, you
19
want us to see it.
and Lordship 100, para, next page Lordship, para 100.
Yes.
Having answered the question of law as
No, please
above.
don't read it because we have told you the reason.
Yes, yes.
We just mark it, we'll go through it.
This is the first appeal of under the commercial code. Lordship. First, before that, no appeal has been filed. Lordship. Just para 100. Having answered the question of law, I also clarify that there may be instances wherein the plaintiff is ready and willing to for a belated written WS to be taken on record subject to payment of the cost. However, it is important to note that parties cannot by consent vest the court with discretionary jurisdiction power which it otherwise is barred from exercising under statute. Jurisdiction can be vested only by a statute and not by consent and acquiescence. It is well settled law that the jurisdiction cannot be conferred on a court by consent, acquiescence, or waiver where there is none, or nor can it can be ousted where there is. So, Lordship, even if on the next date I had supplied the documents, Lordship, and copy of the plaint to the defendant, it does not mean that the defendants will file the WS beyond 120 days, because the plaintiff cannot give consent and his consent is irrelevant, Lordship, having no value. So the second time when I supplied, Lordship, my intention was that there should not be delay in the disposal of the suit. Commercial courts constituted, Lordship, for the special decision disposal of the suits, Lordship. So in view of the letdown apex law let down by the apex court, Lordship, and in view of the Supreme Court decision 2019, the defendants have forfeited the right to file the WS. And from the second, your Lordship may be pleased to consider, from when I supplied second time the copies of the plaints and documents, thereafter the defendant did not file the WS within 120 days. And on the first date, Lordship, when the summons were served, Lordship, the 120 days is counted from the date of service of summons. The provisions of the commercial law does not provide that. It simply provides that 120 days will be counted from the date of receiving the summons. And summons were served on 10/3/23. There is no dispute regarding that. Defendants have also agreed.
We are aware of it.
At least, Lordship, matter may
We'll
be.
pass orders in the by afternoon. We'll pass orders.
Okay. Because if order is Lordship not passed today.
Out of this bench, we are hard pressed of time.
Yes.
Because then there's another division bench. Then I'm rising.
My Lord,
I'm rising at 1 o'clock. I have some
I
administrative
filed
work.
this appeal 15 days ago. There was no nomenclature, no category code is available for
We are aware of
commercial
it.
appeal.
We have seen that note.
Then we filed the petition before the Honorable Chief Justice.
We have seen that note.
Then this has been listed.
You'll have to excuse us today because of the fact that if the dead body would not have come, I would not have shortened the argument. I hope that you will excuse us this time. Also.
Please, my lords. This is a matrimonial appeal. I've come against the interim judgment passed by the Honorable Court below, my lord. My lord would find the judgment at page 52, my lord.
The divorce proceedings were dismissed.
Dismissed, my lord.
Okay.
My lord, may I come to the facts of the case?
Not required.
My lord, in this case, what had
Not
happened?
required. Not required.
My lord.
Mr. Priya Sharma, counsel for the appellant. Matter calendar 28 of Hindu Marriage Act, page 1. MP order, page 2. Admitted for hearing, call for the records, show notice returnable in 4 weeks. The steps within 2 days.
Highly obliged, my lord.
for the first time?
Yes. Husband is before lordship, my lord. At page 37 is the impugned judgment, my lord. Husband filed for dissolution of marriage.
You are against restitution, or you are
Against my lord, not allowing the dissolution of marriage. I
Dissol-
applied for dissolution of marriage.
that was not allowed?
Yes, my wife filed a counterclaim for restitution of marriage.
That was allowed.
That was allowed.
But then your present appeal will have to be dismissed. We have no option but to dismiss your appeal in the motion stage.
My lord, for not getting it.
You did not get it.
Yes.
You see,
Yes.
against the decree of non-granting or decree of divorce, you have filed this appeal.
Yes.
So even if you allow this appeal, it will run contrary to the decree for restitution of conjugal rights.
My lord, I have asked for reversal of the whole.
Then you'll have to file two appeals.
Here only I have put prayers, my lord, that I have assailed the
No, but-
whole judgment, my lord. Both the ways, my lord.
No,
Why,
but
if my-
you see, but
yes.
it's a counterclaim.
Yes.
Counterclaim will proceed as a cross suit. If the principle applies,
Yes.
then either you will have to take a leave to file a common appeal.
Yes.
For that, there is no provision.
Yes.
Otherwise, there will be a second appeal with appeal against the or degree of restitution.
My lord,
Otherwise-
yes, I got your lordship, my lord. But here, since there is a common judgment, my lord.
No,
Judgment
common-
is common.
No, common judgment may be there.
Yes.
You take an example.
Yes.
A writ petition is filed against 10 people.
Yes.
Some relief they are wanting against 10 people.
Yes.
Now, if all want to independently join and all want to join and file a common appeal, that is okay.
Yes.
But if otherwise people file separate appeals,
Yes.
then they'll have to file multiple appeals. All the private respondents who want to file it.
True.
Same principle will apply here.
But
Yeah,
here, my
yeah.
lord, I got your lordship, my lord. But here, since my lord, my prayer was for dissolution of marriage, that was not considered, and counterclaim was filed by my wife for restitution. My lord, I have challenged that also. As it is a common judgment, I have challenged here also. That my prayer is to dismiss that restitution of that counterclaim, my lord. I have put on.
Where have you mentioned that it's a common appeal against both the judgments?
Well, it seems that this is one judgment only, my lord.
But where is the
That is judgment dated judgment of
No.
15/8, my lord.
no? But you see,
Yes.
if you want to file a cross appeal against the decree passed in the application of the respondent, you have to
Yes.
make a mention here at least.
My lord, may I just royal lordship to that prayers, my lord. The third prayer I have set aside and passed the impugned judgment and decree dated demand passed in the counterclaim so filed by the respondent directing the present appellant to restore the conjugal life. At page my lord 14, I have put that, my lord, specific clause.
Mr. Hazarika, we are proposing that we will keep the issue of maintainability of a common appeal open and we are issuing a notice. On the next date, you satisfy us
Yes,
or do whatever is required.
yes. My lord,
Because if an appeal is filed, what is the court fee in Family Courts Act? What is the appeal court fees?
in general, my lord.
No, because I'm not aware of the
Yes.
court fees required to be paid. What is the court fees required to be paid in a family court appeal?
Family court appeal, I will find it.
But then you have to at least give twice the court fees.
My lord, that I will go through it. If I also seek liberty from your lordship, if required, my lord, I will file a separate for that.
No, also that if a common appeal is filed, then you have to pay two court fees.
Then, my lord, I will do the needful. My lord.
So take a call.
Yes, my lord. My lord, if I prefer this common appeal, I may be allowed to, my lord, if required, that requisite court fee.
Oh, okay.
Yes.
Harmira T.H. Hazarika, counsel for the appellant. Next one. The learned counsel for the appellant has submitted that this is a common appeal against the impugn order so and so, page one. Against the dismissal of the suit for divorce and to assail the counterclaim filed by the respondent under Section 9 of the Hindu Marriage Act, seeking restitution of conjugal rights, which was decreed. Next, keeping the issue of maintainability of a common appeal open, issue notice returnable in 4 weeks. The appellant shall take steps within 2 days for service of notice of the respondent, registered post with ED, as well as by usual process. Next. This juncture, the learned counsel for the appellant pays to permit him to file additional court fee if required, and obligor to file a separate appeal. Full stop. Liberty as prayed for is allowed. Next one. Before that, you notice call for the reports. List after 4 weeks.
DP of last month.
Also, this is wrongly listed before this honorable bench. This should go before a single bench.
Single bench. Okay. This both sides are represented. Does this matter before the appropriate single bench?
Perhaps 10 years.
10 years, madam.
More than 10 years will come here.
DP of last month.
Just add there as it is submitted by the learned counsel for the appellant that the punishment is 10 years.
Highly objective.
Item number 4.
Division of appeal under section 374 to 10
How for the
years.
first time?
First time.
10 years.
This is
10 years.
also for 10 years.
So
10
we
years.
go to same order. Mr. C. Barwa. Same order. Is that- What side is it?
No, there is imprisonment for life.
I don't know.
No, it's 302 imprisonment for life. What I can see from the cost
No,
item.
Mr. Barwa must have allowed them remission.
No, they are-
No,
This
Mr.
case- This
Mr.
case
Barwa.
was to be defended by another counsel, my lord.
No, no.
He is doing difficult.
No,
things
it's-
have come.
RI for life.
You see, a dashing counsel may have a power to allow remission.
When we come to be this code, we learn what our court says. Really, we agree on this point. Lordship may, LCM may be called.
392 is 10 years.
302 is there.
I can-
RI for life. This is C. Barwa for the apparent and resident for then the AP for the state. Appeal number 374, page 2. Admit call for the records. Appellant shall take steps within 2 days for respondent is not there. Okay. No, it's not there.
He is there. Vishnu Gogoi,
Vishnu Gogoi.
not required.
Okay. Then as the appellant has been convicted for commission of offense under section 302. And 392 IPC, issuance of notice on respondent number 2 is dispensed with. However, this order shall not preclude the court for issuing notice on the respondent number 2 at a later stage, if so warranted. Rest of the
In
holds.
between, what was the procedure, in what was practiced is, if the informant is a relative, then notices sometimes goes. In between, it was a practice, no? If the informant was a relative of the deceased, victim's family, that way notices are sent. But as it's
LCR complete. Later on going to be channel. कोई वो दरकार नहीं
oh no, এটা যদি আহে আহিব
मैंने कोई से टाउन दरकार लेटर on कोई
আচ্ছা
इसको
আচ্ছা
वेट ना लगे
okay. Lordship has dictated later on if it is required. Then you
No,
can
but
stay.
there's a, what do you call, my brother has a space that
Hmm.
it would be advisable to send it.
Because
once
he
the
is the
respondent
son
is there.
here. Mother is the
The
deceased.
notice within 2 days. For service of notice, steps within 2 days for service of notice and respondent to by usual process as with the registration procedure.
LCR is called.
LCR
It says one.
like
Item number 5.
My brother has a good justification to issue notice
May I please your
on
lordship?
respondent to.
This is statutory appeal filed under section 374(2) of CRPC. Appellant convicted under section 376 A, B and 6 of POCSO lordship
Okay,
for 20 years of imprisonment.
okay. Your name,
Ardeka lordship. Ardeka.
Ms. R. Dekar, counsel for the appellant. Raise hand and I think for this page. 374 2, page 2, Foxhole. Admitted for hearing, call for the records. Appellant shall take steps within 2 days for service of notice and respondent to by registered post with AD. To serve in addition, the land counsel for the appellant shall provide scanned copy of the memo of appeal with enclosures to the registry for onward transmission to the London APP for service of notice on the respondent to through the jurisdictional police station being
Must be Nagaon, I think.
Rupohihat, yes,
Rupohiat.
in the district of Nagaon. Take steps within 2 days and give a scanned copy to the registry for service by this.
Lordship, I is here.
There is an I, yes.
I shall be considered on visit of the LCR. Both sides are represented. Same.
Objection? 4 weeks. 3
Objection.
weeks.
The objection will be filed by the APP.
Lordship.
Matter.
Number 6 for orders.
Yes, your lordship. In this case, the accused has been convicted under section 6 of the POCSO Act.
Your Lordship, paper book is ready. Other side is also appearing. Let the matter be fixed for hearing.
What about service report?
She is appearing, Your
My
Lordship.
lord,
Oh,
I
you're
am
there.
on behalf of respondent number 2 and memo against the memo of appeal. I have filed a affidavit objection, my lord. Yeah,
In a criminal appeal.
against the memo of the appeal, my lord.
In a criminal appeal, what is the requirement of filing an objection by affidavit? In criminal matters, we don't go by pleadings.
Record to class submission.
It is there. It is available. So fix it for hearing then.
My lord, kindly that may be fixed, my lord. That may be fixed.
I have not received the copy of the paper book. Paper book. Objection.
22. This will be listed in the month of November. Also, is a duly represented. The paper book is Prepare and served on council for all sides. This is the matter for hearing in the month of November 2022, 23. November, it will be listed for hearing.
Thank you, sir. My lord, in this case, my lord, your lordship have already gone for the, my lord, most of the evidences, my lord. Just, my lord, I beg to, my lord, revisit the, my lord, PW 1 and PW 2, my lord. PW 1 is, my lord, informant, and PW 2 is the, my lord, wife of, my lord, victim, my lord.
Lordship, on perusal of the case diary, I found some medical documents. I have marked it in yellow color flag.
What are those documents?
What are those documents?
Lordship, regarding the medical treatment, my lord.
Okay.
Yellow flag.
Your hard work is appreciated.
But reference of the case number is, I didn't find it.
It's okay, but
Yes.
whatever it is there in the case diary,
Yes.
and you have also demonstrated that it was received pursuant to order of the trial court
Yes.
that you have flagged. Give us some time. Let us go through it. Hmm. That was Bhuya, you are putting us to more difficult situation.
Yes, sir.
You have another copy of this rules? So last. Civil code, okay. Take into consideration. No, hidden clause, no, somebody will have to bring it to an apartment. Notice now. I think I'm going. Ms. When Mr. Uddin, we are facing a very difficult situation. Part A, Chapter 3, pages 26.
Twenty-six.
26, Rule 29 and 30.
Lordship. Yes. Documents which are not admitted as evidence should not be made part of the record, but should at once be returned to the party by whom they have been produced.
Next.
Documents filed by a party to a proceeding but not admitted in evidence, if not returned earlier, shall at the conclusion of the proceeding be returned to the person producing them or his advocate pleader after he has signed a receipt for the same. If the documents are not taken back before judgment, the presiding officer will note the fact on the order sheet, which will be shown to the party or his advocate pleader and signed by him. Great care should be taken that such documents are not mixed up with exhibits in the case. Unexhibited documents, if not taken back by the parties or the advocate pleader, shall before the judgment is pronounced be removed from the record, yes, and placed elsewhere with a flyleaf attached to them marked with the number of the case, name of the party or his advocate pleader. So in this case, it has not been exhibited, Your Lordship.
No, now you see. Now the question starts.
No, no,
Number one,
no.
this document once not being exhibited is not a part of record.
Yes,
That is one part.
yes,
Second part is that if the document is not a part of the record, for the court to take cognizance of that record is impossible.
impossible.
Third, it is open to either side, either the appellant or the respondent, to bring these documents to our notice,
Yes.
because as on date we can't take notice of that document.
No.
And once we can't take cognizance of that document, you can, there's no impediment for you to bring it to our notice
No,
by
no.
way of an affidavit.
My lord.
Now, even if the document is brought on record or not brought on record, fourth thing is that the position of the appellant is not altered.
Yes,
You get the point.
yes.
Number one,
Yes,
even if we take note of this document, then also the SMCH returned back the deceased,
yes,
and there's a prescription in that prescription come after 7 days for removal of stitches.
yes,
That at that point of time he was not under nobody had a perception that he would die,
yes.
so that is not there.
My lord.
So the document, taking cognizance of the document or not taking of the cognizance doesn't materially affect the position of the appellant.
Appellant.
So this is what we are finding.
Yes,
Now there is another angle to it, which is the fifth angle. Nearly a part of fourth, but still it's a fifth. It will not be expected. Otherwise, we are not saying that you should be partisan, but ideally, the APP will not bring it on record, because otherwise, if you take cognizance of the document, it goes in favor of the appellant.
yes.
So
But it's an unexhibited document,
No,
just like, yes.
No. The repercussions will come to what will happen. But today we don't think it would be appropriate that the APP should bring it on record by saying it, because otherwise this document would help the appellant. The sixth position of which we have said, unexhibited document. You see, unexhibited document doesn't form a part of the record. So I come back to point number one, that if the document is not a part of the record, either of you can bring it on record now.
Yes.
If you file an affidavit,
Yes,
we'll have to take a call in respect of those documents.
yes,
Whatever worth it is, but we'll have to take, at least we'll have to deliberate on that document. But as on date, these documents are not part of the record.
Yes.
That's why I showed you
Yes,
this
my lord.
29 and
Yes, yeah,
30.
Yes.
So this is the legal position. So we are back to even after point number 1, 2, 3, 4, 5, 6, we are back at square one.
She have found the case in that regard. The person died of septicemia. In that case, Honorable Supreme Court has taken different view. Although it was the case under 302, it was converted to 304 part 1.
No, it has to be because otherwise 304 part 1, that is what we are thinking. Because the immediate cost of death,
Yes.
or proximal cause of death would not be the assault.
Assault.
Just give us some time.
Yes. Your lordship, on the first occasion also opined that, my lord, this assuming, my lord, this prosecution case is correct, my lord. Assuming, my lord, your lordship, on the first occasion also opined that, my lord, assuming prosecution case is correct, my lord, that it will not come, my lord, under 302. But if on merit, my lord, I submit.
Very short memory we have.
Yes, my
Very
lord.
short memory we have.
But if, my lord, the matter is finally heard, my lord, I will, my lord, argue differently, my lord.
No, we are hearing on merit because it takes us same amount of time and energy in disposing of a bail application and the appeal. It is almost same for us.
Yes, my lord. Now, my lord, I just, my lord, I beg to revisit the, my lord, this case, my lord, main witness PW1 and PW2, my lord. PW1, my lord,
Just a moment. Mr. Munir. Mr. Munir. I just, I'm so sorry. Today morning I was remembering he's related to you, but I forgot the name. I'm so sorry. He was contemporary to Mr. Rahim Baksh, thin elderly person, fair complexion. He was your uncle or?
I'm not being able to recollect.
Mr. Danish Rahman's elder brother. He was practicing as a lawyer, fair complexion, Ataur Rahman. Ataur Rahman. Is not related to you?
Ataur Rahman from Shantipur, my lord.
Shantipur.
Yes, yes. He expired long back.
No, I was just trying to remember. For some reason,
Just our neighbor.
he is just your neighbor. Okay, I thought it was some relative of yours. Okay.
He is
I
our
was-
neighbor also.
Yes.
Shantipur,
Shantipur.
Masjid Road. And his daughter is a judicial officer.
Okay, I'm not aware. But I was suddenly, in the morning today, I was trying to recollect the gentleman. Yes, his court demeanor was fantastic.
Yes.
Very good court demeanor. Ataur Rahman. But I wasn't able to place him. The name I forgot. So that's why I thought that I would ask. Since I saw you, and just I asked.
my lord, PW1, my lord, in the paper book, my lord, page 14, my lord. I am the informant of the case. I know all the accused persons standing in the dock. My new house is situated towards south of the Panchgram at a distance of around 3 kilometers at village Dolidohar, Grant. My original residence is at Panchgram. I engaged one Chowkidar named Sobikur Rahman to guard the said house and the land that properties at the Dolidohar Grant on 15/10/2010 at about 11 a.m. While I was at Panchgram in my original house, the son of Sobikur Rahman informed me that the accused person Mujibur Rahman, Burawala, Abdul Malik, Abdul Hanan, Songul Ali, Rahmat Ali, Surman Nisa, and Azmat Ali trespassed into my house at Dolidohar Grant and tied my chowkidar Sobikur Rahman and assaulted him so brutally. What in one hand can here and be chopped off and also inflicted blows by means of dao, lathi, etc. on his person. Then immediately I, along with the son of Sobikur, went to the Panchgram PS and Barveli, informed about the incident. Thereafter, I, along with police, went to my said house and found Sobikur lying on the ground in injured condition. There was bleeding from his body. He was in unconscious state. Then we took him to Kalinagar PHC, but doctor referred him to SMC Silchar. He received treatment for 3 days at SMH Silchar, but the doctor told us that there was no chance of recovery of the patient and asked his family members to take him back to his house, and accordingly he was discharged. On next day, he died in the his house on 19/10/2010 at about 5 p.m. On 19/10/2010 in the morning, I lodged an FIR Exhibit 1 is the said FIR Exhibit 1 is my signature. I have mentioned in the said FIR that on 18/10/2010 the accused person trespassed into my said house in the absence of Chowkidar Shafiqur Rahman and took a betel nut, betel leaf and bamboo. On the next day, they also entered into the said house by breaking the lock and looted away many valuable words of ₹50,000. After his death, police came and took the dead body to civil hospital Hailakandi. Fire inquest and postmortem were conducted on the dead body. I attended his janaza. Police recorded my statement. The distance between my house and Pasgram PS is around half kilometer. I did not appoint Shafiqul with any written documents as Chowkidar. I did not see the incident. Police did not ask for any document in respect of my land in Dolidohagan, and hence I did not produce it in the FIR. I have not mentioned my description of the land in the FIR. I did not mention the reason of 5 days delay. But since I was busy in providing treatment to disease, there was some delay. There are 5 persons in my family, including myself. It is not a fact that I have stated falsely that I, along with police, went to my house at Dolidohar and took the disease to Kalinagar PHC. It is not a fact that I did not state before police that the son of Shafiqur Rahman informed me that the accused person assaulted Shafiqur in my house and chopped his ear and hand off. It is not a fact that I did not state before police that after getting the information, I verbally informed the same to Pasgram police, and along with police, I went to my house at Dolidohar where I saw Shafiqur lying on the ground in injured condition, and thereafter I, along with police, took him to Kalinagar PHC. There are both plain and tilla and land in the village Dolidohar. It is not a fact that no treatment was provided to the disease at Kalinagar PHC as well as SMPC. It is not a fact that I have stated falsely that the accused person trespassed into my land and assaulted my Chowkidar Shafiqur. Regarding the land and Dolidohar, there is no other litigation pending. After the incident, when the police visited the place of occurrence for the purpose of investigation, I did not accompany the police. I cannot say what the police found during investigation. It is not a fact that there is no land in my village Dolidohar and no Chowkidar was appointed by me, but the intent to harass the accused person. I have filed the case with false allegations. It is not a fact that the Shafiqur Rahman was not died due to any assault inflicted upon him by the accused person and he died a natural death. Then, my lord, I also beg to refer, my lord, the evidence of PW2. She is, my lord, the wife of the deceased, my lord. I know the accused person. They are from my same village. I know the informant and he is my brother-in-law. About 9 years back, one day on Friday at about 11 a.m., my husband Shafiqur Rahman was in the house of informant in his duty of Chowkidar, and I was in my house. My house and the house of informant are intermined by 3 numbers of Tilla. At that time, 2 small boys came to my home and informed that the accused person were assaulting my husband in the house of informant. Immediately, I started proceeding towards the place of occurrence, and when I reached the nearest tilla of the place of occurrence, from the top of the tilla, I saw the accused person Abdul Malik Chaudhary, Sangul Rahman Ali, Ajmat Ali, Fatar Ali, and Surman Nessa were returning back from the house of informant, being armed with dao, lathi, etc. And when I started running towards the place of occurrence, on the way, the accused person, Fatar and Malik, assaulted me with a lathi. When I reached the house of informant, I found my husband lying on the ground with injuries in unconscious state, and There was profusing bleeding from his body. Thereafter, police came and took my husband to Kalinagar hospital and then to SMCH Silchar. The doctor of SMCH Silchar told us to take my husband to whom and also directed us to provide the foods whatever he likes as he had no scope of recovery. After 4 days of the incident, my husband died. Police brought the dead body of my husband and postmortem and inquest were conducted. In the cross, my lord, there are houses of some people near the place of occurrence. I was informed by Zakir, my grandson, and Nurul Islam. I reached the place of occurrence. I saw the accused person coming out from the place of occurrence, being armed with dao, lathi, etc. The place of occurrence is a Tila homestead land situated towards north of the village part. The house of accused person is situated to the east of the said Tila. When I reached place of occurrence, I did not find any other person among the outsider. During my presence, police personnel came at about 12:30 p.m. It is not a fact that I did not state before the police that two small boys came to my home and informed that the accused persons were assaulting my husband in the house of informant. Immediately, I started proceeding towards the place of occurrence when I reached nearest tilla of the place of occurrence from the top of the tilla, I saw the accused person Abdul Malik Chaudhry, Sangul, Rahman Ali, Ajmat Ali, Fatar Ali, and Sumana Nessa were returning back from the house of informant being armed with the lathi, etc. And when I started running towards the place of occurrence on the way, the accused person Fatar and Malik assaulted me with a lathi and have deposed of same falsely. I have got 3 sons, 1 daughter. My husband has got 2 brothers and their offsprings are still alive and near my house. Also, beside, I cannot say the dark number of the land of the informant in respect of which incident occurred. It is not a fact that my husband was not appointed as chokidar in the house of informant and the accused person never assaulted my husband and me. It is not a fact that the informant has got no land at village Dolino Grant. It is not a fact that I have stated falsely that my husband was treated at Kalinagar Hospital and at the same case. It is not a fact that my husband died a natural death, but due to previous grudge, the informant lodged the case falsely implicating the accused person. My lord, for PW, my lord, I beg to my lord refer PW3 also, my lord, is relative, my lord, of the nephew of the deceased, my lord, age 20, my lord. I know the informant Abdul Razak Chaudhary. I also know the accused person. The deceased Shafiqur Rahman is my own uncle. I work as officer in the teak and betel nut plantation of the informant at Dolidhar Grant. The informant purchased another plot of land where betel nut, coconut, jackfruit trees plantation were there and the guard are the same. The informant employed the deceased Shafiqur Rahman there and Shafiqur Rahman used to reside in the house situated over the said land. About 10-12 years back, one day at about 12 noon, while I was returning to my house from the tea plantation of the informant. On the way, I heard hue and cry in the nearby purchased land of the informant, and I went there and found my uncle Shafiqur Rahman lying on the floor of the house is unstable condition. On being asked, he told me that Abdul Malik and Mujibu assaulted him. I did not see any external injury on his person. Then I saw the accused Abdul Malik was leaving the newly purchased betel nut garden of the informant. I informed the same to the informant and as per his instruction, I brought my uncle to Panchgam PS and then to Kalinagar Hospital. And on being discharged, I took him to original house which is also situated in the same village, Dolly Hall Grant. After about 1 week of the incident, Shafiqur Rahman died. Police held inquest on the dead body in my presence and post-mortem was conducted at SRI Civil Hospital, Hailakandi. Exhibit 2 is the inquest report and Exhibit 2.1 is my signature by Defense Cross, my lord. I did not see the incident of assault in past. I went to the place of occurrence and after about 5 minutes, the other people, namely Sabela, Samir, Sobur, and other gathered there. The informant purchased the land in respect of which the incident occurred from one Abdul Rashid. I cannot say the dark patta numbers etc. of the land from the place of occurrence. The place of the disease is situated at a distance of around 1 kilometer towards north, and in between there are 25 houses. The plantation in which I work is situated at a distance of about 5 kilometers from the place of occurrence. There is a small river, namely Doleshwara, is situated just on the bottom of the Tilla towards east of the place of occurrence. Police came to the place of occurrence and took my uncle, but I cannot say the time and the arrival of the police. I am unable to recall whether police examined me over the matter. I am also unable to recall whether I stated before police what I have stated today before this court. It is not a fact that I have stated falsely that on being asked, my uncle Shafiqur Rahman told me that the accused person Abdul Malik and Majur assaulted him. It is not a fact that I did not state before police that my uncle Shafiqur was working as chowkidar in the newly purchased land of the informant. The informant is also my uncle. It is not a fact that I have deposed falsely on being tutored by the informant. My lord, PW, my lord, it is here say my lord PW4, my lord. His name is Abdul Malik Borbuya, my lord. I know the informant Abdul Razak Choudhury. I also know the accused person. I do not know how Abdul Rahman died. I do not know anything about the occurrence. About 3-4 years back, one day, police went to my village and gathered, getting me on the way, took my signature on a paper. The signature appears in the seizure list is of mine. Exhibit 3 is the seizure list and Exhibit 1 is my signature. Police also took signature of one Salim. The paper which my signature was taken, something was written there, but the contents of it were not read over to me. My lord, I beg to refer, my lord, PW5, my lord, he is son of the disease, my lord. I know the informant Abdul Razak Choudhury. I also know the accused person. They are of my same village. The disease Shafiqur Rahman is my father. My father was working as a caretaker in the house and Betelnut garden of the informant about 4 or 5 years back. One day in the afternoon, I was informed that the accused person assaulted my father in the Betelnut garden of the informant. Thereafter, I finished my work and went towards my house, and on the way, I found my father in an ambulance, and I was reported that from the SMC Silchar, he was taken back. I was has the marks of injury in the body. At that time, my father was alive. Thereafter, on being advised by the informant, I took my father to my house. The informant told me to take my father to SMCH after 2 days, but after 1 day at night, my father expired in my house. Police came and conducted inquest on the dead body of my father, and I put my thumb impression on the inquest report. Cross, my lord, I did not see the incident of assault. My house and the place where my father was working are being intermingled by a hillock of length of 2.5 kilometers approximately. I visited the place of occurrence. The house of Abdul Mannan is situated to the north side of the place of occurrence. On the relevant day, we did not file any FIR. I cannot say the dag and patta number, etc. of the land over which the incident occurred. I cannot say the place of at Silchar where my father received treatment on the relevant day of occurrence. It is not a fact that after 5 days of the occurrence, the inquest was conducted on the dead body of my father. It is not a fact that I have stated falsely that I was informed that the accused person assaulted my father. It is not a fact that the accused person did not assault my father and my father did not die due to the assault of the accused person. My lord, I beg to refer, my lord, the PWC, 6, my lord. PW6, my lord, is also son of the my lord disease. I know the informant Abdul Razak Chaudhary. I also know the accused person. They are of my same village. The disease Shafiqur Rahman is my father. My father was working as a caretaker in the house and Betelnut garden of the informant. About 4 or 5 years back, one day in the afternoon, I was informed that accused person assaulted my father in the Betelnut garden of the informant. Thereafter, I finished my works and went towards my home, and on the way, I found my father in an ambulance, and I was reported that from the same feature he was taken back. I saw the marks of injury in his body. At that time, my father was alive. Thereafter, on being advised by the informant, I took my father to my house. The informant told me to take my father to the same seat after 4 days, but after one day at night, my father expired in my house. Police came and conducted inquest on the dead body of my father, and I put my signature on the inquest report. Exhibit 2 is the inquest report of my father, and Exhibit 2 is my signature. My mother, Al-Fatun Nessa, sister Krishna Begum, and my neighbors people, including my cousin Sabur Samir, told me that at the time of occurrence, on hearing hue and cry when they went to the place of occurrence, they found Mujibur Rahman Gurawala, his son, namely Mannan, the wife of Gurawala Abdul Malik Rahman Azmot, and Fatar Ali being armed with dagger, dao, lati, etc. coming out on the place of occurrence. It is also reported to me that my mother and other, as mentioned above, found my father lying on the ground in the injured condition in a pool of blood. Defense, my lord, it is not, I did not see the incident of assault. My house and the place of where my father was working were being intermingled by a hillock of length of 2.5 kilometers approximately. I visited the place of occurrence. The house of Abdul Mannan is situated to the north side of the place of occurrence. On the relevant day, we did not file any FIR. I cannot say the dag and patta number, etc. of the land over which the incident occurred. I cannot say the place at Silchar where my father received treatment on the relevant day of occurrence. It is not a fact that after 5 days of the occurrence, the inquest was conducted on the dead body of my father. It is not a fact that I have stated falsely that I was informed that the accused person assaulted my father. It is not a fact that the accused person did not assault my father and my father did not die due to the assault of the accused person. On the day of occurrence, the case was filed before police. I put my signature in the inquest report at Hailakandi. On the day of occurrence, police visited the place of occurrence. It is not a fact that my father was not a caretaker of the Betelnut garden come house of the complainant. It is not a fact that I have deposed falsely that my mother, brother, sister, and other neighbors people reported me that they found the accused person coming out of place of occurrence after assaulting my father. My lord, I also beg to defer, my lord, PW 7, my lord, page 27, my lord, for the paper book. I know the informant of this case. I know all the accused persons. The incident occurred about 10-11 years ago in front of my house. I was sitting in the shop in front of my house. Some people have taken away Shafiqur Rahman in an injured condition by a van, and prior to that Shafiqur Rahman drank water from the shop where I was sitting. Shafiqur Rahman, while drinking water, stated Abdul Hanan and Abdul Malik had physically assaulted him. He had not stated name of any other person. Then Shafiqur Rahman was taken to hospital. I heard that Shafiqur Rahman died after 3-4 days at his residence. During investigation, police recorded my statement. I have this much to say. In the cross, my lord, it is stated my house was situated about half kilometer away towards north side where I was sitting at the time. I was working as shopkeeper at that time for about 1.5 years. It was 11 a.m. or 12 noon, and at that time where there was no other customer in my shop, I was not the eyewitness how Shafiqur Rahman has sustained injuries. I cannot say how accompany Shafiqur Rahman at that point of time. I have no idea where the incident taken place. I have not made the information about 1 or 2 days after police recorded my statement. It is not a fact that in my statement under section 161 CRPC, I have not mentioned that some people have taken away Shafiqur Rahman in an injured condition by a van, and prior to that, Shafiqur Rahman drank water from the shop where I was sitting. It is not a fact that in my statement under section 161 CRPC, I have not mentioned that Shafiqur Rahman, while drinking water, stated that Abdul Hanan and Abdul Malik had physically assaulted him. It is not a fact that I have stated falsely that Shafiqur Rahman, while drinking water, stated Abdul Hanan and Abdul Malik had physically assaulted him. It is not a fact that I am not a shopkeeper. It is not a fact that owing to good relations with informant, I am deposing falsely at his behest. My lord, FIR writer is my lord, page 21, my lord, Karan Acharji. He wrote the FIR, my lord. I have seen working as lead writer in the district judiciary Hailakandi on 19/10/2010. One Abdul Razak Chaudhary of the Gram asked me to write an Ejhar. As per his instruction, I scribed the instructed Ejhar and handed over the same to him. Exhibit P1, P2 is my signature. I have no personal knowledge about the incident. Doctors, my lord, I beg to defer, my lord, doctor's evidence as PW 9, my lord, part of protein, page, my lord, 30, PW 9, part of protein, there. He states, my lord, I have been working as the medical officer Ayur of Sorujini PHC at Kalinagar on 15/10/2010. Having police requisition in connection with a Panchram police outpost case, I medically examined one Shafiqur Rahman Chaudhary, son of late Manohar Ali Chaudhary of village Dalidohar Grant in Hailakandi district. On examination, I found the following. Number Roman 1, multiple abrasion of various sizes over the left ear, multiple abrasion of various sizes over the right forearm, both anterior and posterior aspect, and Roman 3, tenderness over the hip joint. I referred the patient to Silchar Medical College and Hospital after giving first aid treatment. From the record, it appears that the patient expired on 20/10/2010. Subsequently and accordingly, Dr. Khairudraman Chaudhary, since disease of Teskera Civil Hospital, conducted postmortem examination of the dead body of Shafiqur Rahman Chaudhary, I would be able to depose on the basis of the record. The doctor opined that cause of death is due to coma following massive external and intracranial hemorrhage following previous head injury caused by blunt object. Exhibit P4 under objection is my report wherein Exhibit P41 is my signature, Exhibit P5 is the postmortem report, wherein Exhibit P51 is the signature of Dr. Khairuzzaman Chaudhary, since this is Exhibit 52 is the signature of the Joint Director of Health Services, Hailakandi, which I know being a colleague. My lord, this cross, my lord, page 32. Exhibit P4 is a photostat copy. It is not written in any given format. It was issued on 1710. 1710. This bears no seal. I did not mention the nature of injury. The GDNT number or PS case number is also not mentioned. Abrasion is a superficial injury. Tenderness may be caused by falling also. As we have no sufficient resources for further examination, I referred the patient to SMCH Silchar. I did not mention any fracture of the patient during that time. It is not a fact that I did not examine the above mentioned patient nor found any injury on his person. The exhibit 5 is silent as to whether the patient Shafiqur Rahman Chaudhary was admitted to SK Rai Civil Hospital, Hailakandi or not. The nature of injuries in the postmortem report, whether fresh or old, are not mentioned. The injuries mentioned in the postmortem report may be caused if a person falls from a hilltop. My lord, I beg to refer my lord PW10. He is the my lord.
We'll take a break and come back.
I'll take a short break and come back.
My lord. Of the complainant located at Dolly tied up the watchman Shafiqur Rahman and assaulted him brutally. Consequently, the watchman became unconscious. The accused person also cut the on one hand and one ear of the Shafiqur Rahman. The case diary reveals that on receipt of the jar and on being entrusted the then IO Sri P.K. Rajbongshi visited the place of occurrence, recorded the statement of the available witnesses, and gave a rough sketch map of the place of occurrence. Each one jata, a fishing hook-like weapon, one sharp piece of bamboo, and one bamboo stick. As per my information, P.K. Rajbongshi has already. Records reveal that subsequently the injured Shafiqur Rahman Chaudhary expired on 2010 at about 4 a.m. Thereafter, the investigating officer made arrangement for his
Just a minute, Mr. Babu. Just a minute. This again, sir, Bhavya, this page 34
My lord.
seized article is one jata.
Yes.
Fishing hook like weapon. What is a jata? We don't know.
My lord, so far I know, my lord, there is, my lord, some sharp, my lord, small, my lord, iron stick, my lord, tied up with a, my lord, bamboo stick or my lord, stick, my
Lordship,
lord. When my lord
to catch
goes,
fishes?
my lord,
in
there-
Assamese it is called jung. Jung.
No, we are asking you for some reason. You see, here the scissor is of one jata,
Yes,
a fishing hook like weapon,
yes,
one sharp piece of bamboo,
yes.
one bamboo stick. Therefore, description of 3 items are given. In fishing hook, it doesn't say fishing hook with stick.
Yes.
That's why we are asking. But there is a reason for us asking. Because jata is explained,
Yes.
fishing hook like weapon. But then it doesn't say accompanied with a stick or what you call mounted on a stick,
Yes.
or it can be mounted on a thread. We don't know those things. That's why we are asking you.
Lordship, no description as such.
No description. If you please see the scissor list. Exhibit 3, that is the scissor list.
Page 116. 116.
112.
6.
116.
With a bamboo handle.
With a bamboo handle.
Yes.
The length of jata with handle is about 8 cubits.
8 cubits.
Now, what is a cubit?
Lordship is aware of, my lord.
Cubit is one, one handful of size is 1
I
cubit.
think, my lord.
Cubit.
.44 centimeter, 18 inches or 44 centimeter.
My lord.
1 cubit is 44 centimeter or 18 inches.
Lordship.
Now this is how much?
8.
8. So 8 into 18 inches would be 96.
12 feet, my lord. 12 feet, my lord. 18 inch into 8, 12.
18, 12 feet. 18 inches is 1.5 feet.
Yes.
1.5 feet. So 8 will be, no,
12 feet.
12 feet. 12 feet. You're right.
But injury from jata, my lord, is as per medical report, my lord, the first prima facie, my lord, there is no injury. Prima facie, my lord, as per medical, my lord, witness, my lord, there is no injury found in the on the dead body from jata like weapon.
So that's why we are evaluating. That's why we try to evaluate. Okay, please proceed.
Yes, my lord, the page 34 of the my lord paper book, last 2 lines, my lord. Hereafter, the investigating officer made arrangement for his inquest and also for his postmortem examination. The accused person, Shangul and Abdul Malik, were arrested while other 6 were absconded. After completion of the investigation,
Means
finding
behind this state, we have a procedure for prescribed for the manner in which the inquest should be made. Is it available?
172.
As yesterday I was trying to search, I could not find
My
it.
lord.
We on so far as my research is concerned, we found only with there is a protocol in of NHRC.
My lord.
in case of custodial death,
Yes, my lord.
we have a procedure prescribed for inquest, but I did not find.
The policeman will have to check.
We have a policeman, but it's not there. Yesterday, I tried to
Lordship.
read through it, but I could not get it. No, because there are less chances of finding it in the Assam Police Manual.
My lord.
It's only my suggestion. I have not, I did not find it. Therefore, I am not saying it with authority,
My lord.
but I am saying it with my, with some, by a notion which I am having. You see, the inquest is done by an executive magistrate.
My lord.
He will not be bound by the police manual.
Yes.
So
My
therefore, it is the executive who will be performing a duty.
My lord.
So they will definitely not know what
The
is there in the
procedure.
Assam Police Manual.
My lord.
So therefore, they are to be trained separately. Therefore, I was just, it was just a notion.
Yes, but we got citations, my lord, in lapses, like in violation of procedural formality, with inquest is done, the accused gets the benefit. There are judgments, my lord, but today have not brought
No,
it,
no.
my lord.
But
How it
you
was
see,
to be
in
conducted,
the
my lord.
state, in a separate state, they might be having it,
My lord.
but we are not getting it.
My lord.
When you search in the net,
Yes,
you will find one website coming up, Puducherry Police,
my lord.
but we are not getting that.
Yes.
The manual of the actual manual or the guidelines.
My lord.
What is being referred to is NHRC, National Human Rights Commission protocol for inquest in cases of persons dying in judicial custody.
Yes.
So just take your time, just a query.
Yes.
Not for this case, but
My lord.
a general idea.
Lordship.
When we are taking up this bench for some time,
Yes.
let
My
us be sure what we are
Yes, my lord.
handling.
Lordship.
Please start your-
If required, you can ask someone to tell
Yes,
us.
I will.
After completion of the investigation finding prima facie case against the accused person, the IO PK Rajvangshi had submitted charge sheet against the accused person for trial under section 147, 148, 149, 447, 448, 325, 326, 379, 380 oblique 302 IPC of the IPC. Exhibit 3 is the seizure list, while Exhibit P32 is the signature of the PK Rajvangshi. Exhibit P2 is the inquest, wherein Exhibit P23 is the signature of PK Rajvangshi. Exhibit P6 is the sketch map, wherein Exhibit P61 is the signature of the PK Rajvangshi. Exhibit P7 is the charge sheet, where Exhibit P71 is the signature of PK Rajvangshi, which I know. In the cross, my lord, I have no personal knowledge about the primary investigation. The FIR was registered in the Pasaram Police Outpost on 19/10/2010 by GDNT number so dated 19/10/2010, and thereafter the same was forwarded to Alcahol Police Station on that date. The case diary does not reveal any GDNT for 15/10/2010 in connection with the instant case. The record reveals that the investigation was initiated from 19/10/2010. As per Ejahar, one hand and one ear of the victim was chopped off, but record does not reveal recovery of the same by the investigating officer. There is no mention in the case diary that on 18/10/2010 the injured was taken up by the police authority for providing treatment. As per case diary, the investigation was initiated on 19/10/2010. On that day, the IO prepared the seizure list and recorded the statement of Muhammad Alfa Thun Bibi, Abdul Matin Majumdar, and Salimuddin. The seizure list was not caused seen by the learned CGM. The case study does not disclose any mark of violence at the place of occurrence. During investigation, police did not record the statement of Abdul Manan, which mentioned in Exhibit P6 in Index C. During investigation, police did not collect any document regarding the ownership of the land, farmhouse at place of occurrence, and any document pertaining to his engagement as a watchman. Reason for delay in filing case is not mentioned in the FIR. PW1 did not state before the IO that the son of Shafiqur Rahman informed him that the accused person assaulted Shafiqur in his house and chopped his ear and hand off. PW1 did not state before the IO that thereafter getting the information, he verbally informed the same to the Pasgram police, and along with police he went to his house at Dalidohar, where he saw Shafiqur Rahman lying on the ground in injured condition, and thereafter he, along with police, took the injured to Kalinagar PH. PW2 Alpha Sunnesa did not state before IO that two small boys came to her house and informed that the accused person were assaulting her husband in the house of informant. Immediately she started proceeding towards the place of occurrence, and when she reached nearest pillar of the place of occurrence, from the top of the tilla she saw the accused person, namely Abdul Malik Chaudhuri, Sangul, Rahman Ali, Azmat Ali, Fatar Ali, and Samarun Nessa were returning back from the house of the informant, being armed with dao, lati, etc. And when she started running towards the place of occurrence on the way, the accused person Fatar and Malik assaulted her with a lati. PW3, namely Jamaluddin, did not state before the IO that his uncle Shafiqur was working as a chokidar in the newly purchased land of the informant. PW7, namely Abdul Hasim, did not state before the IO that some people have taken away Shafiqur in an injured condition by an van, and prior to that, Shafiqur Rahman drank water from the shop where he was sitting, and at that time Shafiqur Rahman stated that Abdul Hanan Abdul Malik physically assaulted him. I only registered the case after its transfer from Algaur police station to Pasgram police station. It is not a fact that we find the charge sheet against the accused person perfunctorily without proper investigation. My lord, now my lord, I beg to refer my lord post-mortem report, my lord. The relevant portion, my lord, page 125, my lord.
Yes.
More detailed description of the injury or disease, my lord. The findings are antemortem in nature. The history of alleged assault on 15/10/2010 with the bruise on the left temporal region proves that the injury was grievous in nature, as it resulted in fracture of the left temporal bone and rupture of the left middle meningeal artery. The rupture of the left middle meningeal artery resulted in gradual and constant hemorrhage, which caused the massive extradural hemorrhage and 138 grams of clotted blood. When the intracranial pressure increased, the victim must have lost consciousness and subsequently died due to coma. My lord, this is their, my lord, case, my lord. But my lord, here one thing, my lord, not mentioned, my lord, whether, my lord, this injury was sufficient in normal course. My
In the
lord.
postmortem, that report is that opinion is never expressed.
Yes, my lord.
That you'll have to ask in the dispel in the cross examination.
Yes,
Postmortem is just a finding.
yes,
It's not an opinion of the author.
yes, my lord. My lord, here in this case, my lord, I have seen, my lord, regarding, my lord, FIR, my lord, ask, my lord. FIR, my lord. The FIR, my lord, it is though, my lord, admittedly filed, my lord, after almost 5 days later. If FIR, my lord, incident happened, my lord, on my lord, 10, my lord, and FIR was lodged, my 15/10, my lord, and FIR was lodged on 19, my lord. But exact, my lord, description of the injury was, my lord, apparently not given in the FIR, my lord. That apart, my lord, another, my lord, aspect of the matter is that, my lord, here, my lord, all the witnesses, my lord,
Just a minute.
then, my lord, all the, my lord, evidences I have seen, my lord, there states, my lord, different, my lord, date of death, my lord. One, my lord, PW1 stated that, my lord, 3 days, my lord, treatment at Silchar, and, my lord, next day he died, my lord. Then, my lord, wife says, my lord, after
PW says what? PW1?
PW1 says, my lord, 3 days treatment, my lord, at SMCH, and next day died. PW, my lord, 2, wife says, my lord, after 4 days of incident died, my lord. PW, my lord, 3 says, my lord, nephew, my lord. To that extent, he is very important, my lord. He says, my lord, after 1 week, my lord, died.
PW?
PW3, nephew, my lord, of the disease, he says, my lord, after 1 week died, my lord.
He's a distant relative.
Yeah.
He's a distant relative.
Yes, my lord.
So he added 2 or 3 days.
Yes, my lord.
Whoever are close, they give a shorter time, 3 days. Everybody has complaints with wife. She says 4 days. Then nephew, more distant, 7 days.
They thought, my lord, if we say same thing, it will be weird. We say differently, but in this point, my lord,
If everybody says the same, then you will say they are tutored witness.
yes, my lord.
They are all saying
They
4
are,
days.
my lord, they are different.
All are saying 4 days. So then you will say that they are tutored witness.
More dates are there, my lord. Son, my lord. Son said, my lord, page 23, my lord, PW 5, my lord. He said, my lord, after 2 days from the same day of incident, my lord. And his brother, my lord, 6, my lord, he said, my lord, after 4 days, my lord. PW 6, my lord. After 6 days, my lord. Then, my lord, IO says, my lord, he died on, my lord, 2010, 2023. And, my lord, it is also corroborated by the, my lord, the doctor also. Doctor also said, my lord, he died on 2010, my lord.
IO is PW?
IO, my lord, PW
10.
10, my lord.
And doctor?
Doctor 9, my lord. They both said, my lord, injured died on 2010. My lord. Here,
Yes.
my lord, another my lord, I aspect my lord, with all
You see,
the
this, although we have smiled at that date, but there's not a material, what you call, what is it that called? It's a not a very material contradiction which will demolish the case, because you see, when we are calculating, so 15 plus 15 an incident and 20.
my lord.
So somebody will say that 15 minus 20 minus 15 is 5.
My lord, with
No,
all
I'm
the-
just saying it's a normal human tendency.
sir. Now-
20 minus 10 is 5. Somebody will say that no, the date of occurrence I am calculating. So from there it will be 6 days. He died on the 6th day. Correct. Because you see, the same thing happens when we say our date of birth in Hindi. Because you see, let us say a child born on a particular day, it's not calculated as the birthday. So after a year, it is his first birthday. But at times we say that he has entered his second year. You get it? You get the point. So you see, it's the first birthday of the child. One says that no, he has entered the second year,
Yeah, my lord.
and one will say that no, he has entered it was his first birthday. So there are ways of expression. One day, because when we do the legal calculation under the Limitation Act, then we subtract the day on which the incident occurred. So supposing the judgment is delivered on 1st of January, we deduct that 1st of January, and the limitation period starts from 2nd. So calculation of the limitation under the Limitation Act is exclusion of 1 day.
My lord. My lord, here one in this case, my lord, I have understood your lordship point, my lord. But here in this case, my lord, why I have referred those evidence, my lord, because for this, with all respect, my lord, for this, my lord, nature and my lord relationship with the disease, my lord, this contradiction may be, my lord, major, because my lord, they are all are my lord family members, my lord. Those family members cannot, my lord, say date of exact death, my lord. My lord, it is for normal, my lord, human being or reasonable human being, my lord, it is not possible. His nephew, his wife, his son, and his, my lord, brother-in-law. So definitely, my lord, they would have, my lord, if they are a normal independent witness, my lord, chance witness, etc., they may casually say, my lord, yes, 4 days, 5 days, 3 days. But for them, my lord, it is not possible. Because this incident was false. Therefore, my lord, they have stated family member, though they are family member, my lord, they said date of death is different, my lord. This is my humble submission. Now, my lord, PW, my lord, PW1, my lord, he himself, my lord, stated in his cross-examination, the first line, my lord, that place of, my lord, occurrence and police station is just, my lord, half kilometer. Page 15, my lord.
Yes.
Half kilometer, my lord, 15. He said, my lord, police station is just half kilometer away from the place of occurrence. If, my lord, police station is half kilometer away and FIR is lodged, my lord, after 4 or 5 days, my lord, later, it is also, my lord, serious lapse, my lord. Creates doubts, my lord, regarding, my lord, the implication of this accused person, my lord. They thought, my lord, one person died and thought, my lord, who would be implicated to take revenge, my lord, for personnel. He made all those persons, my lord, accused in this case, my lord. And, my lord, another, my lord, contradiction, my lord, with all respect, my lord, I have to state that, my lord, their main foundation is that, my lord, after incident, immediately they went to the place of occurrence, my lord. and they brought the victim, my lord, to the, my lord, police station, my lord. Then they, my lord, police escorted, my lord, to the, my lord, hospital, my lord. But here, my lord, IO, my lord, categorically stated that, my lord, there is that this case has no foundation from the, my lord, 1510. This case has foundation only, my lord, from 1910. In the criminal case, my lord, with my little understanding, my lord, these are, my lord, serious matter, my lord. Here, my lord, I beg to, my lord,
That PW3 said he went to police station.
one, my lord.
PW1.
One. My lord. Oh, everybody said, my lord, on the same day, my lord, he was brought to, my lord, police, my lord, and he was hospitalized in the, my lord, PHC, my lord. But, my lord, police said, my lord, they have no record that this man was taken by them on 1510, my lord, and they took the, my lord, the victim to hospital on that day, my lord. The police said, my lord, categorically said that, my lord, then they have all record from 19, when, my lord, FIR was lodged, my lord. These things, why, my lord, as a, my lord, defense counsel, my lord, I know, my lord. When, my lord, case comes, my lord, the prosecution side try to, my lord, fill up the lacuna, my lord. Therefore, they, my lord, give idea. You say why you have not given treatment, why you have not filed the FIR initially. So if lordship believes this their story, then, my lord, delay is not there. This is mistake of the police. If we believe, my lord, he was brought to hospital, but doctor did not give the, my lord, treatment, then, my lord, we tried. Doctor did not. Patient, my lord, is serious from the day first, my lord. These are their, my lord, the layman persons, my lord, idea. But intellectual sections, my lord, this type of, my lord, idea will not work, my lord, because these are, my lord, not natural for normal human being, my lord. My lord, I beg to, my lord, prima facie, my lord, refer 6 judgment, my lord. I have made out, my lord, note, my lord. These are judgments, my lord. Here, my lord, first judgment I have referred, my lord, only 24 hours, my lord, delayed. Supreme Court, my lord, viewed, my lord, seriously, my lord. There are many judgments, my lord, only just I this.
Uh,
1993, 3 SCC 629, my lord.
I'm sending you the 15 times. পার্টি থেকে পুলিশের পার্লার গেল কিন্তু থানা চেঞ্জ হয়ে গেল কিছু পাঞ্জাব পুলিশ এতে কালেকশন করা নাই
And, my lord, we are defense, my lord. My lord, 1993, 3 SCC, page my lord 629, my lord, para 8, my lord. I have given the list, my lord, list of the my lord judgment. My lord. Yes. 620. This judgment has my lord, I have my lord hard copy also, my lord.
You can give it, it will be better.
It saves a lot of time.
Yes, my lord. My lord, in this case, my lord, what happened? Has they are alleging that my lord, husband and wife, my lord, they are my lord, farmer, my lord, and they are staying in a shed, my lord. In the meantime, 4 or 5 persons came, my lord, and in front of her, my lord, husband was killed. In this regard, my lord, lordship, paragraph, my lord, 8, my lord. Paragraph 8, my lord. There is no doubt that even where there is only a sole eyewitness of the crime, a conviction may be recorded against the accused concerned, provided that the court which hears such witness regards him as honest and truthful. But prudence requires that one corroboration should be sought from the other prosecution evidence in support of the testimony of the solitary witness, particularly where such witness also happens to be closely related to the deceased and the accused are those against whom some motive or ill will is suggested. Now, in the instant case, a careful analysis of the evidence relating to the inordinate delay involved in the giving of the first information to the police.
Mr. Barbia, just a moment. Sorry to interrupt you, but you see what has happened here. This case of Ramji Surya Padvi is a case where the Sessions Court had acquitted the accused. High Court reversed it and convicted it.
Yes.
So therefore, you see, when the Supreme Court is analyzing the evidence,
Yes.
it is with the premises that order of acquittal should not be normally or casually
Yes,
interfered with,
Yes.
and therefore,
No,
you
no,
see-
I am just law part, my lord, I am citing. Law part, my lord, what, my lord, in this regard, what, my lord, law analysis in this paragraph, my lord. And my lord, here in this case, only 24 hours delayed FIR was Supreme Court viewed seriously, my lord.
No, but you see, appreciation becomes different
Yes,
because the Sessions Court had acquitted it. So we must understand the judgment and the principles of acquittal.
Yes, ma'am.
But then the court says that there must be a overwhelming material before the High Court or the Superior Court to convict the person. Acquittal is not likely to is not to be lightly interpreted with casually, because you see here the finding is, I'll show it to you. Last line of this that paragraph 10 you are reading. The
Paragraph
reason,
8, my lord.
no, paragraph 10 now.
Yes, ma'am.
The last 5 lines. It may be noted that distance between Molgi and village so and so are hardly 3 miles, but the khabar reached the Molgi outpost according to the prosecution nearly 24 hours after the incident. The reason given by the prosecution for this inordinate is hardly convincing. The important aspect of the case has been overlooked by the High Court.
Yes, ma'am.
So this is, you see, with the principle of what you call acquittal, because otherwise 24 hours delay, you will find several cases of various courts where this delays of 1 or 2 days is not a major delay. So we are analyzing it with the background fact that there was a case of acquittal.
No, my lord, Supreme Court, my lord, convicted, and judgment is given, my lord, against conviction.
High Court gave conviction.
Yes, my lord. And Supreme Court give the judgment against the conviction, my lord.
Yes,
So
acquittal.
acquitted, my lord.
Acquittal.
So
So
therefore,
therefore, you see,
basically, my lord, and now your lordship is considering the, my lord, against the, my lord, conviction of the session judgment.
in conviction, the principles are different. reversal of the order of acquittal, there
Basically, my lord,
it's more what you call intrinsic examination to find out overwhelming what you call evidence which leads to the conviction.
my lord, with
You-
all
you see,
respect, my lord, I beg to state, my lord, when my lord Supreme Court was, my lord, dealing the matter, it was dealing
No,
against
no,
the
no,
conviction.
no. Then you see, come to page 10 again, in the middle. We do not find a proper discussion. You've seen that.
Yes, sir.
We do not find a proper discussion of the judgment of the High Court about various versions of the prosecution evidence about giving the first information to the police, which we have pointed out above. In their two perspectives, the High Court has oversimplified this issue and has observed, in this case, bearing in mind the place where the incident occurred, we find no reasonable delay in so and so. Therefore, you see, the factual aspects are not considered by the High Court.
Yes, sir.
It-
Here, my lord,
Supreme-
it is-
according to the Supreme Court, the High Court oversimplified it.
yes, sir.
and
Yeah, in this case, my lord, the learned trial court, my lord, did not consider the, my lord, delay part, my lord.
So once there is an acquittal, principles change.
Basically, my lord, judgment, your lordship is also, my lord, sitting against the, my lord, conviction, and Supreme Court was basically, my lord, ultimately, my lord, was sitting, my lord, against the conviction, my lord.
But background fact is
But
of
background
acquittal.
different, my lord. But it is 100% correct, my lord, it is background, but only, my lord, law have discussed, my lord, and facts, my lord, they have, my lord, viewed, my lord. Just
I'll give you a third reason why. I'll give you a third reason why. A paragraph 10, what do you call paragraph 10, you see the language.
my lord.
The High Court, which was hearing an appeal against a judgment of acquittal, has not bestowed due care on the principles governing its jurisdiction. While there is no doubt that the jurisdiction of appellate court is coextensive with that of the trial court, in the case of appeal against judgment of acquittal, this is the principle.
Yes, my lord.
It cannot totally brush aside the appreciation of evidence by the trial court. The reasons for reversing a judgment of acquittal should be cogent, and if two views are reasonably possible, the appellate court should be slow in interfering with the judgment. So you see, the trial court, when it acquitted, it took cognizance of the fact that there was a short delay, and therefore the what you call the delay is fatal. So therefore, it is not open to the High Court to give a different interpretation.
Yes, sir.
That's why I'm saying that I have been reading this judgment with some circumspection, because it is in the original court the man got an acquittal. Same principle, if I read in the present case, that will be it may not be proper. Just why I'm reading
My
it
lord,
in part
though,
and
my
part.
lord, in the, my lord, in my case, my lord, there is no eyewitness.
That's okay. We take
But
that.
only just, my lord, saying, my lord, why one's place said, my lord, she saw, my lord, accused are coming from the, my lord, place of occurrence with some, my lord, weapons, my lord. Therefore, my lord, I just, if, my lord, her evidence is just that part, my lord, just, my lord, her, my lord, he also needs to be corroborated, my lord. And FIR in my case, my lord, 5 days later, my lord, it was lodged, my lord. And my lord, next case, my lord, 2012 9 SCC, my lord. 9 SCC, page, my lord, 249, my lord. There are 21 and, my lord, 22, my lord. 2012 9 SCC.
Mr. Borbe will continue some other day. Your other matter was fixed when? Your other matter was fixed when? Not that. Death preference.
Oh, I'm not aware of this. As Jahan she appeared.
Ah.
Death preference of the research, definitely.
Yesterday. Tuesday. Then we'll fix this on Wednesday.
Can it be on Thursday, Your Lordship?
Huh?
Thursday?
No difficulty. The submissions of Mr. A.M. Bagher, the counsel for the appellant, remains inconclusive. This B. Bhuya Leonard, senior counsel and APP for the state is present. List as a part and matter on Thursday. Okay. 21. Yes. Yes, you wanted to say something?
Item number, next item, item number 8. Can it be next week or Thursday?
Give the dates. The court master will give it. The list of next week you want? Next week you want? Next week. Item number? 8. Next week. With a positive time matter could not be taken out.
I, my lord, the accused number, my lord, the appellant number 6, my lord, as per my instruction is very seriously ill, my lord. After
that's why-
suddenly he has gone in the old age, my lord, jail, my lord, the anxiety is much higher and he is also.
Yeah, you're right. You're right. There is a possibility. But we are guided by, you see, this very, what do you call, whenever it comes to illness, my mind always travels, I don't know why, to a very celebrity politician in Bihar. Whenever he's in jail, he is always